This is Barry Zalma speaking for Claim School Incorporated's Zalma on Insurance. Today I'd like to speak about why an insurer must always demand restitution of all expenses incurred to avoid an insurance fraud when the fraud perpetrator is convicted. It also should understand that when one is convicted of insurance fraud, California statutes at least make it a requirement that the convicted pay restitution to the insurer, not only what it paid to him under the policy, but also the attorney's fees incurred by the perpetrator's insurer to defeat the fraud. And this case explains why an insured who puts goods in storage finds that it's a stupid way to commit insurance fraud and why he was convicted. After a jury convicted Patrick Elliot Lee of 8 counts of insurance fraud under Penal Code sections 550, subsections A1, B, and B1, the trial court ordered him to pay restitution to the insurers he defrauded. In the People v. Patrick Elliot Lee, the California Court of Appeals on June 24, 2022, convicted him, and the convicted felon tried multiple arguments to avoid jail and restitution. On February 10, 2015, San Pablo police officer Matthew Brown responded to the scene of a reported burglary, where Lee's wife told him she had returned home to find all of the Lee's property missing. Lee subsequently filed a theft claim under his renter's insurance policy with Homesite Insurance Company, telling the insurer that the allegedly stolen property exceeded $50,000 in value and that Lee had hired an attorney to assist him with the claim. Advised by Brown of his suspicion, California Department of Insurance Detective Herndon discovered that Lee had communicated with Officer Brown by email from a Gmail account. When Lee rented a storage unit 8 days before the reported burglary, he also used the Gmail address. After he moved property out of that storage unit, he rented a second unit near his home in Menlo Park, again using the Gmail address. Detective Herndon's investigation also uncovered a car insurance claim Lee had made on October 9, 2014, under his policy with Progressive Insurance. On June 16, 2014, Herndon sought a search warrant for Lee's Gmail address for the date range from November 12, 2014 through June 16, 2015, which covered both claims. A Contra Costa County Superior Court judge signed the Gmail warrant on June 16, 2015. Items discovered by the warrant matched photographs of the items Lee had reported stolen in his Homesite Insurance claim. In their case in chief, the People examined Leon Craig, the Progressive claim representative who processed Lee's October 9, 2014 claim regarding the scratch damage to his Porsche. Craig testified that Lee's insurance policy entitled him to a rental car benefit while his Porsche was being repaired. Upon hearing from Lee that he was taking the Porsche to be repaired in Colorado, Craig authorized a $720 payment to provide Lee with a rental car for 18 days. When Craig was asked to view photographs of the Porsche taken after Lee's rental car had been returned, he testified that they depicted the same scratch damage that Lee supposedly had repaired. The People cross-examined Lee about his finances, On commercial pilot, Lee moved from Colorado to California in 2014 to work for Air Methods, who led Lee to believe he would earn more money in California than he ultimately did. The prosecutor showed Lee a November 12, 2014 email in which Lee complained about his compensation to management at Air Methods. Having referred to the email, Lee testified at the time he sent the email he had made $37,000 year to date, an income he described as pretty pitiful. In argument, the prosecutor recounted Lee's financial problems, telling the jury that money was tight, so the Lees invented an insurance claim. The jury found both Lee and his wife guilty as charged. On December 20, 2019, the trial court ordered Lee to pay restitution to his victims. In addition to the money Lee owed Progressive, Lee was ordered to pay Homesite $18,000 for the economic loss caused by Lee's fraudulent theft claim, as well as $64,280.03 in attorney's fees. The trial court rejected Lee's argument that the terms of his earlier March 2018 settlement with Homesite precluded the court from ordering Lee to pay attorney's fees. The Fourth Amendment to the United States Constitution provides that no warrant shall issue but upon probable cause, supported by oath or affirmation. Probable cause, the court found, was established in abundance by an affidavit sworn by Detective Herndon, a California Department of Insurance detective, certified public accountant, and certified fraud examiner. In the affidavit, Herndon describes the origins and course of his investigation into the theft claim made by Lee against the renter's insurance policy with Homesite. Herndon then recounts the facts underlying his suspicion that the theft claim was fraudulent. The affidavit provided more than a substantial basis for concluding a fair probability existed that a search would uncover wrongdoing. The court concluded it was entirely reasonable to infer from the facts Detective Herndon relayed that Lee moved his property into storage, filed a theft claim with Homesite, and then removed the property from storage once Homesite had settled the claim and Lee believed the danger of any investigation had passed. In short, the affidavit established probable cause to believe that Lee committed insurance fraud. A jury found beyond a reasonable doubt that Lee defrauded Progressive by availing himself of a rental car under false pretenses, and the people's evidence was sufficient to show that Lee violated Penal Code Section 550. The jury resolved any conflict in favor of the people's evidence, and that resolution will never be disturbed on appeal. As part of the restitution order entered after Lee's conviction, he was ordered to repay Homesite the $18,000 it had paid him to settle the fraudulent theft claim against Lee's renter's insurance policy. In addition, Lee was ordered to pay Homesite $64,280.03 in attorney's fees, because in May of 2015, Homesite had settled Lee's theft claim for $18,000. However, nearly 3 years later, in March of 2018, Lee agreed to pay Homesite $18,000 to settle any civil lawsuits related to the theft claim, with each side to bear its own attorney's fees and costs. According to Lee, the trial court should have held Homesite to the terms of the settlement agreement and declined to order restitution for attorney's fees. At the time the restitution order was entered, however, on December 20, 2019, Lee had still not paid Homesite the $18,000 he owed under the March 2018 settlement agreement, and a restitution order is enforceable as a civil judgment. See People v. Guardado, 1995 Court of Appeal decision. Thus, by aiding the prosecution of Lee's criminal case, Homesite's attorneys helped to secure a conviction and, in turn, a restitution order having the same effect as a civil judgment. By virtue of those efforts, Homesite's attorneys put Homesite in a better position to collect the $18,000 it was already owed. For that reason, their fees were reasonable costs of collection under Section 1202.4 subdivision F3H. The judgment was therefore affirmed. In my opinion, insurance fraud is a serious felony in most states, including California, and the statute allows the insurer defrauded to seek restitution from the criminal. In this case, failure to pay the ordered restitution can either void a probation and put the man back in jail or add to the sentence. Every insurer who, as a victim of a crime of insurance fraud, should demand restitution, including restitution of the attorney's fees incurred to defeat the fraudulent claim. This video was culled from my blog post and is available at zalma.com/blog. Thank you for your attention.